How are assets and debts divided between the parties in a divorce? Attorney Ben Stevens says, in a divorce or separation action in South Carolina, the marital estate, which consists of the marital assets and marital debts, will be equitably divided between the parties. Marital assets are those which have been acquired by either party during the marriage with marital funds. Typically, it does not matter whether the asset is titled in the husband's name, the wife's name, or both names. Non-marital assets can include assets owned by either party prior to the marriage, gifts made to either party during the marriage, or inheritance received during the marriage. Typically, non-marital assets are not subject to equitable distribution. However, it is possible for non-marital assets to become marital assets under certain circumstances. Marital debts are those debts incurred during the marriage for a marital purpose. Although marital estates in South Carolina are divided approximately equally between the parties in most cases, the court is not required to make an exact 50-50 allocation. The court looks at all the factors involved in each particular case, which include the direct and indirect contributions made by each party, the length of the marriage, and any marital misconduct by either party. If you are facing a separation or divorce, it is particularly important to consult an experienced attorney as early as possible to determine which items should and should not be included in the marital estate, and to discuss what portion you might expect to receive. There are steps that you can take, even before the action is filed, to help protect your interests as much as possible. Should you fail to take responsible steps to do so, you could face a much tougher, more difficult case, and it's always better to be proactive than reactive in these situations. To request a consultation with Ben Stevens in Spartanburg, South Carolina, contact the Stevens firm at 864-598-9172 or visit them on the web at www.scfamilylaw.com.